After 2 months of argument, sometimes fierce and other times light-hearted, the Supreme Court is set to give its judgment in less than 12 hours. Tonight, we bring you a recap of the 2020 election petition.
On the basis of the foregoing election results, and by the power vested in me as the chairperson of the Electoral Commission of Ghana and the returning officer of the presidential election, it is my duty and honor to declare Nana Addo Dankwa Akufo-Addo as President-elect of the Republic of Ghana.
9 December 2020. Electoral Commission Chairperson Jean Mensah officially declaring President Akufo-Addo as having been validly elected as President. This was immediately met with protests by the NDC, who challenged the EC's figures, insisting the results were flawed. NDC presidential candidate John Mahama, along with other party leaders, argued the EC's correction of its own figures buttressed their point.
The sacred verdict of the people must be respected. It must be protected. It has been my pledge throughout my time of service as a representative to the good people of Ghana to do exactly that. And that is why I stand before you tonight unwilling to accept the fictionalized results of a flawed election.
On December 30, after several street protests, John Mahama filed a petition at the Supreme Court seeking an annulment of the 2020 election results and an order of the court directed at the EC to conduct another election between himself and President Akufo-Addo. But documents it submitted to the court were riddled with errors. On January 14, 2021, the court sat for the first time to hear the petition and granted unanimously the request to amend the documents. The Supreme Court subsequently, however, dismissed a request for interrogatories to be served on the Electoral Commission. John Mahama was seeking to get the EC chairperson to answer 12 questions, which, in his opinion, would have aided the speedy resolution of the trial.
In the case of the interrogatories, if leave were granted and those answers were available, we would expect that the answers to those interrogatories would be available to put in evidence, which will then limit the scope of controversy.
Then came the time to call witnesses. Although John Mahama stated in his petition that he was calling 5, his lawyers called only 3 witnesses to the dock: John Singisiedun Ketia, Dr. Michael Pesa-White, and later Rojo Metal Nunu.
My Lord, you claim my agents did not sign, which means that it's part of our case that the figures are in contention. But in the presidential elections, regions are not won.
I can say and maintain that it is on the basis of her instruction that we exited the place.
And even whilst there, you were offered tea and biscuits, not so?
I was offered tea. I wasn't offered any biscuits.
The court also rejected an attempt by lawyers for John Mahama to inspect some 6 original documents at the Electoral Commission.
In the instant case, the applicant has not raised any issue that he has no copies of the documents of the subject of this application. Of the fact that the proceedings so far shows the petitioner has copies of all the documents, the subject of this application. We are of the opinion that no proper case has been made before us to warrant the exercise of our discretion in favor of the applicant.
When lawyers for the petitioner closed their case, it was expected that the EC and President Akufo-Addo would open their cases and call their witnesses. But to the surprise of many, including the justices, the respondents opted not to call any witnesses.
We do not intend to call any witness. And my Lord, let me complete.
Order.
We do not intend to call any witness because in our view, they have not satisfied the burden of proof.
Lawyers for John Mahama proceeded to make a case to the court to compel Jean Mensah to testify. But the court rejected their plea, saying it cannot compel the EC chairperson to testify against her will. This ruling was appealed, but the court unanimously rejected the review application, insisting it had no powers to force witnesses to testify. The petitioner subsequently applied to the court to reopen his case and issue a subpoena to the EC chairperson to testify as a hostile witness. But that also failed. Subsequently, a review application against this ruling was filed in court, only to be dismissed by an enhanced 9-member panel. Of course, one cannot forget when the spokesperson for the petitioner's legal team, Dr. Dominic Ayine, was hauled before the court for making comments suggesting the panel had predetermined the case.
Lord Chief Justice, I did say those words. My attention was drawn to the fact that I might have crossed the line by Mr. Frank Davis. And Your Lordship, on the advice and consultation with my counsel, I have written to the court rendering an unqualified apology. I delivered that letter this morning to the Registrar of the Supreme Court to bring it to Your Lordship's attention.
All the parties in this litigation have filed their written closing addresses, and the court will render its judgment on the petition on Thursday, March 4. It's left to be seen if the 7-member panel of the court will affirm the victory of President Akufo-Addo or will order a rerun, as hoped for by John Mahama.
As Akwa indicated in the complex case, heeding the promptings of conscience, as he put it, heeding fidelity to the judicial oath, he found it appropriate to reverse a decision of the ordinary bench. May each of your lordships decide in accordance with your conscience and your judicial oath. Ultimately, and even more profoundly, it is for the chairperson of the first respondent to come forward to testify as she indicated an oath she would do. I conclude with prophetic words that were spoken centuries ago. For they sow the wind, and they shall reap the whirlwind. These are the words of the prophet Hosea, to be found in Hosea chapter 8, verse 7. He that has an ear, let him hear.